Good afternoon and welcome to the thorough newspaper analysis for 16th May 2022. Today we have two articles which have been taken from the Hindu editorial. Number one, in abeyance of section 124A, a provisional relief, which talks about the sedition charges that are now being held in abeyance by the Supreme Court until the parliamentary committee replies back on it, whether they will scrap the provisions or whether they will keep it in an amended form. The second article for today is this Delhi High Court split verdict needs to be resolved. This article is based on, as you know, and as the country is rife with the split verdict that has been reached upon by the two justices of the Delhi High Court on whether the marital rape exception should be kept or should be scrapped. Following that, as you know, we have the news update and the legal news, which are a part of LawSikho's initiative to keep its students and readers updated with the current affairs that is happening in and around of India, so that you're thoroughly prepared with the current affairs when it comes in your prelims examinations. So before we move on for today, we would like to congratulate the winners who went forward and attempted the quiz that was stated inside the thorough newspaper analysis in the YouTube comment section. The respective winners are Parvesh Kumar, Hani Malhotra, Anamika Verma, Shivani Dinkar, and Megha. Congratulations to you guys and keep participating in the quiz as and when it appears. So, the daily TNE quiz is something that we have been hosting for around 2 weeks now. So, what we do is we prepare 10 questions, a questionnaire, MCQ based, for you to attempt and revise what you have seen in the previous day's TNE. So all you have to do is keep an eye out for the links which are shared on your WhatsApp and Telegram groups at 8 a.m. every day. Now, by clicking on the link, it's a Google form link, you will be able to attempt the quiz, and the quiz remains open until 11 a.m. The winners for the quiz is announced every day at 9 p.m. and you will also get a weekly leaderboard. So for the first article today, in abeyance of section 124A, a provisional relief. So in the case of S.G. Vambatkari versus Union of India, the three-judge bench in SC have effectively suspended the use of section 124A of IPC. The provision of sedition has a history of being used by governments, even post-independence, for stifling democratic dissent. So the charge of sedition was always meant to be used as a restraint on dissent and crush opposition. Now, if you look back into the annals of history, you will see that the charges of sedition were brought against people like Mahatma Gandhi and Bal Gangadhar Tilak. Now, why were they targeted under sedition charges? So they went forward and they criticized the steps and the policies that were being undertaken by the English government back then. And in order to make sure that this growing sense of dissatisfaction did not grow among the native Indians, the English government would go forward, bring sedition charges against them and transfer them to jails. So when finally we got our freedom and when we moved forward to draft our Indian constitution, K.M. Munshi argued forcefully that sedition charges should not be included in the Indian constitution as a means to restrain free speech, as it would only showcase an erroneous precedent of perpetuating the provision under section 124A. Now, Munshi's argument was heard and paid heed to, and hence the amendment sailed through, and the Indian constitution did not impose a restriction on free speech. Now, why we today consider that the section 124A provision is archaic and it should be scrapped? We live in a democracy. In a democracy, if you have a problem with a policy or with anything whatsoever, you are free to voice your dissent. You are free to give voice to your opinions that you hold in a peaceful manner. So one of the wordings of this provision is that disaffection towards the government. Now, when we talk about disaffection towards the government, this term is very vague and it ought to have no place in a penal statute of a democratic country. Now, during modern times, it has also been seen that even the most benign form of opposition, the most common form of opposition, someone comes up and says, I don't like this, or this is something that I think is not beneficial to the community at large, or this ostracizes someone from the greater community. Comments like these have been met with charges of sedition. And this is why it is pertinent for Supreme Court and the Parliament to look into these provisions and make sure that these provisions are not accepted in our judicial system, in our penal statutes, because this will only and only forcefully quell any form of dissent or dissenting opinions. Further, there is also one more thing that the Indian government as well as the judiciary should look upon. Even if the sedition stands cast aside, it truly must be seen as a success for freedom. And it must also be made sure that the same is not made pointless, because the government do have statutes like UAPA, which we have seen to be repeatedly being used to quell dissent. So if today the judiciary and the government move forward and cast aside sedition, they must also make sure that the arbitrary charges that can be brought under UAPA are also limited or cast aside, because they do not have a place in a civilized society. For the next article today, we have this Delhi High Court verdict needs to be resolved. Now, the Delhi High Court gave a split verdict when deciding on the validity of marital rape exception. So in this case, under the observations that have been held by Justice Shagde, rape is when a woman is forced to have non-consensual sex. To this end, the relationship that she shares with the perpetrator is immaterial, whether it is a stranger, whether it is someone in the family, whether it is her husband, her brother, her father, the relationship does not matter. The only thing that matters is that she was forced into having sex, it was non-consensual, and hence it should be brought under the charges of rape. Further, Article 14 holds that equals should be treated equally, and hence bringing a ground of discrimination or a disparity based on marriage is not tenable under the law. Justice Harishankar, however, holds that this exception of marital rape upholds the sanctity of the institution of marriage as we view it in the Indian community. And based on this, the distinction drawn between marriage and between a married woman and an unmarried woman is constitutionally valid. However, he also holds that being married contains a legitimate expectation of sex. However, the degree of this legitimacy of this expectation is not elaborated upon, which proves to be one of the more vaguer grounds of the judgment. Further, he also holds that this legitimacy that he's talking of, the legitimate expectation of sex in a marriage, it ends where the right to bodily autonomy begins for a woman. However, he also believes that the same would not be classified as rape. So the question that comes here is that, as Justice Shagde rightfully held, that rape is when a woman is forced to have non-consensual sex. Justice Harishankar is also saying that the legitimacy ends when the right to bodily autonomy begins. So under the circumstances where the right to bodily autonomy is breached, why can't we call that rape? Now, the issue with this view that Justice Harishankar has put forward, the issue with this is twofold. One, he asserts that a rape by a stranger is worse than a rape committed by a husband. And secondly, which is also in line with the first statement, is that it flattens the trauma of a rape survivor without an iota of evidence or statistics. And it also negates the bodily autonomy that he himself propagated in his judgment. For the news update today, India wins Thomas Cup. Dishing out a performance for the ages, India's men's badminton lifted the Thomas Cup title with a commanding 3-0 win over the powerhouse Indonesia, which is a historic triumph that will enhance the country's status in the sport. Now, the question for you is, Indonesia was a defending champion. How many times have Indonesia won this title of the Thomas Cup? Secondly, Manik Saha sworn in as the CM. BJP State President Manik Saha was sworn in as the Chief Minister of Tripura after Biplab Dev tendered a sudden resignation. Governor S.N. Arya administered the oath to Saha, a Rajya Sabha MP, at the Raj Bhavan. Thirdly, we have Finland confirms bid to join NATO. Sweden and Finland have confirmed they will apply for NATO membership in a historic shift that comes as a result of Russia's invasion of Ukraine. In Sweden, the governing Social Democrats said that they backed the joining of the Western Security Alliance, paving the way for the country to apply. The announcement came soon after Finland formally accepted it too would apply to join the grouping. So the question for today is that how many nations are there under the NATO alliance apart from Finland and Sweden? So if you know the answers to the previous question and this question, go forward and comment it in the comment box below the video. Number 4 is a sad news, and it is truly a sorry day for Australian cricket. In another tragic blow to Australian cricket, Andrew Symonds has died in a car accident aged 46. The former Australian all-rounder was killed about 50 kilometers outside Townsville on Saturday night. A Queensland police statement says Symonds was in a single car crash at about 11 p.m. For the fifth article today, we have the first National Film Festival of Jammu and Kashmir. Jammu and Kashmir's first ever National Film Festival, which is going to begin on June 15th, will give a golden chance to the Indian filmmakers, music producers, and artists to win numerous awards under different categories. Number 6, Himachal's first science center in Palampur. Union Minister for Information, Broadcasting and Sports and Youth Affairs, Anurag Thakur, today inaugurated the Himachal's first science center at Palampur in the Kangra district. Addressing the gathering on the occasion, Anurag Thakur said that the Science Center at Palampur is the first science center of its kind in the state, which has been built at a cost of about rupees 9 crore. For the seventh article today and the final news update, Devshayam Pillai to be declared saint by the Vatican. Devshayam Pillai was born a Hindu in the Kanyakumari district of Tamil Nadu, and he converted to Christianity in the 18th century. He is also to become the first Indian layman to be declared a saint by the Vatican. For the legal updates, we have Section 5 of the Limitation Act is not applicable to proceedings under Section 34 of Arbitration and Conciliation Act, and the same is being held by Rajasthan High Court. So the Rajasthan High Court has observed that the provisions of Section 5 of the Limitation Act does not apply to the proceedings contained under Section 34 of the Arbitration and Conciliation Act of 1996. And the same has been held in the state of Rajasthan and another versus Mrs. Godhara Construction Company. For the second article today, we have the High Court cannot terminate the mandate of arbitrator in an application under Section 11, subsection 6 of the Arbitration Act, and the same has been held by the Supreme Court. So the Supreme Court observed that a dispute on the mandate of the arbitrator being terminated on the ground mentioned in Section 14, Part 1, Part A of the Arbitration and Conciliation Act cannot be decided on an application filed under Section 11, subsection 6 of the Act. And the same has been held in the case of Swadesh Kumar Agarwal versus Dinesh Kumar Agarwal. So this was all for today. For free study materials and TNA PDF slides, please join our Telegram channel, the link for which you can find in the description, or you can also scan this QR code which is given on the screen. Remember the Google form link that we were talking about in the beginning of the presentation? You will also find the Google form link every morning at 8 a.m. if you join this Telegram channel. You can also follow us on our Instagram channels, LawSikho.Judiciary, LawSikho CLAT Prep, and UGCNet_LawSikho. For any further information, please feel free to visit www.lawsikho.com. Thank you.